Welcome back to Courtroom Chronicles. Today's docket is packed with tension, truth, and a touch of Texas heat. From child injury charges and rejected plea deals to shocking drug violations and last-minute resets, this courtroom has it all. You'll see judges walking tightropes between mercy and justice, defendants taking chances, and lawyers scrambling to keep up. Stay locked in, because one wrong word in here can change a life forever.
The announcement.
You signed a rejection.
Oh, is there something on the tablet? Can y'all check the tablet, please?
That's not a tablet.
Great.
Here it is.
Okay. So, again, Ms. Joseph, what you're charged with is a state jail felony offense, and that's from February 20th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment could be between 6 months and up to 2 years in a state jail prison. Do you understand? Yes. And I think I'm about to have...
Here's where it gets interesting. The judge offers Desandra Joseph a lifeline for years deferred probation, meaning no jail time if she stays clean and follows probation rules. But Joseph rejects it, choosing trial instead. That's a gutsy move for a state jail felony carrying up to 2 years behind bars. The judge makes it crystal clear. Once the trial date is set, the offer disappears. This is a crucial legal moment. Plea deadlines are final. No take. What would you have done? Take the deal or roll the dice.
Something, maybe. What? 4 years. It's gone.
Sorry. Four different.
Oh, okay, I was about to say, it can't be that. Okay, and so, somewhere there is a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year deferred probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that? Yes, ma'am. Also, I want to make sure you understand that once I put your case on the trial docket, then I won't accept this plea agreement after today. So if there's unless there's a change in some information that your attorney or the state's attorney gets. Do you understand that as well? Yes, ma'am. And do you want to reject that offer and have your case set for trial? Yes, ma'am. Okay, we'll get it set for trial, and Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Yes. All right, so Mr. Rojas, you're released. Ms. Joseph, if you'll have a seat over here on this side of the courtroom, the clerk will call you up in a few minutes with that information. Yes. And so do we have it? Yes. You got it? Okay. Yes. I forgot that I can't find the last one. Okay. Let's see. Teresa Taylor, Mr. Rojas.
Judge, we just found out she's.
Trying to confirm but I'm not able to confirm that. Okay, and I'll call the district attorney's office. That should resolve our case.
So what I'll do, so this is 23 DCCR 2120. Would you call Teresa Taylor? All right, I have the bondsman notified us that she is in the Hardin County Jail, and so based on that, I am going to find that she's at large without proper bond. I'm going to raise her bond in this case to $100,000, and then we'll see if she bonds out over there. We'll have a hold on her so we can get her back over here, see what happens. Thank you. Thank you. And then you've got Anthony Williams. It's a sentencing, Mr. Rojas.
He's here.
Anthony Williams?
Good morning, you're Anthony Williams. And Mr. Williams, this is cause number 24, DCCR 0401. You were previously in court, entered a plea of guilty to evading detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Mr. Smith?
Yes, Judge.
Any additions or corrections?
Not from the state.
No, Your Honor.
All right, then, Mr. Williams, I am going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but I'm going to suspend that and place you on probation for 7 years. You're ordered to pay a $1,000 fine and to follow all of the rules.
Anthony Williams takes a plea for evading arrest with a motor vehicle. The judge follows the deal: 10 years suspended for 7 years probation. But here's the catch. Probation is a second chance with strings attached. One violation, even a missed check-in, and that full 10-year sentence can snap right back. The firearm restriction admonishment is standard under Texas law. But it's not just a formality. Losing gun rights permanently is a heavy consequence many don't consider. This case is a perfect example of how a light sentence can still carry lifelong impact.
And conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence, while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, and you could be looking at that 10-year sentence that you were already agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right? Just have a seat here in the courtroom. Probation will call you when she's ready to go over your paperwork. Good luck to you, sir. Ms. Holmes, you've got Christopher Burkett. All right, you're Christopher Burkett. And Mr. Burkett, this is 25 DCCR 0358, and you're charged with burglary of a habitation. Part of your bond conditions were that you had to have a drug patch put on, and that drug patch has tested positive for cocaine. So,
And here's the kind of moment that sends defense attorneys scrambling. Burkett's drug patch tests positive for cocaine. Under bond rules, that's a direct violation. The judge wastes no time, immediate testing ordered. No debate, no delay. In Texas, bond conditions are part of the law, not suggestions. A single failed test can revoke bond and land you back in custody. The courtroom tone shifts from procedural to serious, a sharp reminder that accountability doesn't wait for excuses.
all right, have a seat in the jury box. Let's get them tested. I lose Dustin again. I keep losing Dustin. And
Yes, we actually
Hold on a
submitted a
second.
deal on that one.
So we turned in papers. So
Okay.
it probably just hasn't gone through the prosecutor
I'll hold
yet.
it.
I just submitted it.
Perfect. And then what about Gregory Sinclair?
Sinclair?
Gregory Sinclair, cause number 25, DCCR 0471.
Make sure this case specifically for one issue.
Good morning, you're Gregory Sinclair? And Mr. Sinclair is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
Judge, we're just asking for more time to review the evidence in this case.
State's not posted.
All right, so I'll just do a normal reset. Mr. Sinclair, make sure you stay in touch with Mr. Galmore. Once he gets all the evidence, you need to go and discovery, go visit with him so that we can try to get an announcement, okay? All right, you're free to go. Ms. Holmes, you've got Caden Jones, 2 cases.
Do we have an agreement?
Hang on, let's get her. Good morning. Are you Caden Jones? And this is cause number 24, DCCR 2155 and 2156. Ms. Jones is charged with assault on a peace officer and obstruction or retaliation. And what is the announcement?
Your Honor, we do have an agreement for the obstruction retaliation will be reduced.
Hold on a second. Hold it down. Sir. Go ahead.
The obstruction retaliation will be reduced to a terroristic threat, a misdemeanor.
Okay.
And with a dismissal in the assault.
Okay.
And so if we could get some time to get it refiled, it's my understanding it'll be refiled to the 18th and we will.
Okay, so it needs a refile, not just a lesser, it's
Yes, Judge, I
different.
think it'll be cleaner that way, and it will still involve language involved in the public servant on that terrorist.
Okay, all right, so I'll just do a normal reset.
Okay.
So that should give y'all plenty of time to get it taken care of and not have to come back here, but if anything does happen and that doesn't get taken care of, you'll need to come back here on that court date, okay?
If she'll just come upstairs and provide verification of that next Thursday when she does enter that plea on this.
Okay, thank you. Thank you, Ms. Holmes.
Yes, ma'am.
And then you've got Keisha Victoria.
Yes, sir. She's outside. Oh, she's right there.
Finally, some good news for a defendant, Caden Jones, lands a plea deal that drops an obstruction and retaliation charge to a misdemeanor terroristic threat, with a related assault case dismissed. That's a massive downgrade from a felony. The defense and prosecution both agree to clean up the paperwork before refiling. It's a quiet win, but legally significant. The difference between a felony record and a misdemeanor can change someone's entire future. Would you call that justice or a lucky break?
Mr. Smith on Keisha Victoria. Good morning. Are you Keisha Victoria? And this is 24 DCCR 2331. Ms. Victoria is charged with tampering or fabricating physical evidence. And what is the announcement?
Yes, Your Honor. I did have an appointment scheduled with Ms. Victoria, but she missed it. She was not able to get off of work, so I have not met with her.
Okay.
I also realized that I was appointed to represent both her and a co-defendant, so I
Okay.
guess I may need them to sign those waivers. I was appointed to her and Nakia Brandon.
Have you had have you visited with Ms. Brandon?
Mr. Brandon.
Mr.
yes.
Brandon,
And
you've
he was-
already visited with him?
Yes, I've visited with him.
Okay, so why don't I do this just to make it clean,
Okay.
is I'm going to remove you from Ms. Victoria's case, leave you on Mr. Brandon's case.
Okay.
Ms. Victoria will appoint someone else this morning. If you'll just have a seat here in the courtroom, the clerk will call you up and let you know who your new attorney is, okay? All right.
Is that the only co-defendant? Is there only one co-defendant?
No, it's,
No, there's two. There's
Well, I need to know.
Nakia Brandon and Almina Miles.
Almeda is in custody. She's already pled.
She pled July 27th.
We don't, it doesn't matter. We need to know who the attorneys are, and just what the names are. It doesn't show up for some reason anymore when there are co-defendants. So that's okay. Y'all take, if y'all will help
And no, it
Kelly,
wasn't me,
please.
'cause I know I didn't represent her. Oh, to appoint the same. Yeah.
Right. Monique Wynn, Ms. Holmes. Good morning. Are you Monique Wynn? And this is 24 DCCR 1298. Ms. Wynn is charged with theft of property. And what is the announcement?
So, Your Honor, we were advised, Ms. Wynn, there were thefts that spanned over several counties in which she has been given time in certain ones, probation in certain counties. And so I talked with Mr. Coleman in regards to the time that she has served about getting her credit. Look, she was in custody for a year, and she was recently released in May. So we want to get proof of that credit so that we can give her credit for the time on this case.
Okay, so I'll just do a normal reset. Ms. Wynn, make sure you stay in touch with Ms. Holmes, and then we'll see if we can get your case taken care of at the next court date. Okay? Thank you. You're free to go. Mr. Galmore on Charles Newman. Good morning. Are you Charles Newman? And Mr. Galmore, will your client waive the formal reading of the indictment? Mr. Newman, in cause number 25, DCCR 0545, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from November 22nd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Galmore? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation. And it looks like there's a co-defendant's case that would get dismissed based on this plea, correct? Also, do you understand, sir, that if you're not a...
Finally, some good news for a defendant, Caden Jones, lands a plea deal that drops an obstruction and retaliation charge to a misdemeanor terroristic threat, with a related assault case dismissed. That's a massive downgrade from a felony. The defense and prosecution both agree to clean up the paperwork before refiling. It's a quiet win, but legally significant. The difference between a felony record and a misdemeanor can change someone's entire future. Would you call that justice or a lucky break?
U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Newman is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay? We'll see you back at sentencing.
Discovery.
Yes. Mr. Galmore, you have your discovery.
Miss Victoria.
2 announcements whenever the court...
Yeah, once you make sure you get him to sign that real quick before he leaves the courtroom. And then I'll call your,
Sign right here, put your phone. Tomorrow, call him and make an appointment.
somebody. It's outside. Do you have Dustin's thing for me to sign? Kelton Hebert, Mr. Galmore. And you need to get the DA to sign that one before, and then give it back. All right, sir, you Kelton Hebert? Yes, ma'am. And this is 24 DCCR 1498. Mr. Hebert is charged with evading arrest or detention with the use of a vehicle, and what is the announcement?
Judge, we need one more announcement date. There are some videos. There was a conversation that we located on a video, but haven't listened to it yet. And there may be another video coming from the police, but regardless, I think we can have this resolved next time.
State's not supposed to reset, Judge. There was some discussions about what, if anything, was on video, and also discussion about if there is another video that exists, Judge. State's not supposed to.
Okay, I'll just do a normal reset so y'all can get that figured out. Mr. Hebert, stay in touch with Mr. Galmore so that once he gets everything, you guys can go over it and see if we can get an announcement that next court date. Okay, free to go. Mr. Crenshaw, you've got Christopher Street.
Yes, sir.
Good morning. Good morning. Are you Christopher Street? And this is 24 DCCR 2058. Mr. Street is charged with theft of property. And what is the announcement?
Judge, we got a revised offer this morning, and if we could just have one more standard reset, my client needs to come up with a restitution upfront in full, and that is his intent to do that, and I think we can get this resolved at the next setting.
All right, so this will be the final reset. Looks like you were hired back in January, so this will be it. If you get the restitution, great. It'll take care of however y'all, whatever. If not, there needs to be something else that you guys are discussing just in case, okay? We'll see you at the next court date.
Thank you.
And then Guillermo Galvin, Mr. Crenshaw. Good morning, you're Guillermo Galvin, and this is 24 DCCR 2321. Mr. Galvin is charged with driving while intoxicated, third or more, and what is the announcement?
Judge, this is going to be refiled as a misdemeanor, and we have a couple of weeks to get that refile done in the police set in the misdemeanor court, and once that's done, I'll send the paperwork to Ms. Morfino, and she'll submit a dismissal.
All right, so what I'll do a normal reset. That gives y'all hopefully plenty of time to get that taken care of. If everything works out, you don't have to come back to this court. If for some reason it doesn't happen before the next court date, then we'll just need to come back here and get an update.
Judge, he's provided over the pendency of this case quite a bit of documentation with respect to his attending rehab, having a handheld that he uses 3 times a day, I believe, kind of around his work schedule. I think Johnny's or whomever in error sent another of Mr. Crenshaw's clients with the last name similar to me to confirm all of the negatives on that. So if I could just get that documentation corrected, we'll take care of it and have a date certain.
Okay.
And I did send the correct documentation to her this morning.
Okay, perfect. Sounds good. All right. Well, we may see you back in 30 days, but hopefully not.
But
Okay.
just to be on the safe side, can we still admonish him that with respect to having that handheld, continuing it until the plea?
Yeah, you're still under all the same bond conditions, so make sure you continue to do everything you're supposed to, and then once you take care of that case, you'll have certain conditions of any probation. You'll be required to follow those too.
And at that point, we'll determine whether an interlock or continuing with that
Sure.
handheld will be best.
Okay, sounds good. Thank you.
Thank you, Judge.
Mr. Kimler, we lost Mr. Kimler and Ms. Holmes. Oh, she's done, huh? Oh, no, we've got a drug test on hers. And then we've got Mr. Gertz and Mr. Kimler. 8.
Good morning.
Good morning, ma'am. You're Desiree Kirks.
Yes, ma'am.
And Ms. Kirks, in cause number 24, DCCR 0518, you're charged with the third-degree felony offense of deadly conduct discharging a firearm from February 9th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Kimler's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 10-year deferred probation, a $500 fine, And you would be required to follow any and all rules of probation. Do you understand what the offer is?
Yes, ma'am.
You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you're found guilty and what your possibilities are or options are if you go to trial. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, and Mr. Nichols, is there any reason to believe that that offer would change
I
or
don't
any
see
information you don't
reason.
have?
I don't see anything at this point, Your Honor.
So, Ms. Kirks, I want to make sure you understand that after today, I will not accept this plea agreement. So if you change your mind later, you could enter a plea of guilty, but it would be to something different or just open to the court. Do you understand?
Yes, ma'am.
All right, and so we will get it set on the trial docket. Mr. Kimler will begin preparation for trial. All right, you're free to go. And then on Ryan Hodge, Mr. Kimler. Good morning. Are you Ryan Hodge? And Mr. Hodge is charged in cause number 24, DCCR 1167, with evading arrest or detention with the use of a vehicle. And Mr. Kimler, what is the announcement?
Your Honor, the state has suggested that perhaps I sit down with Mr. Hodge. He's from out of state. He lives in Oklahoma, and look at the video from this, and, so he can be perhaps better aware of the circumstances of the case.
I would think
This
that would
time
be
he's-
important.
He's not prepared to enter a plea.
So here's what I'm going to do. I'm going to reset the case just one time. Mr. Hodge, while you're in town, get with Mr. Kimler. Y'all figure it out. I want you to take a look at that video between now and the next court date so we can get an announcement at the next court date. Okay.
He had, I'm sorry to interrupt, now, he had been on quite a few jail dockets, and now that he's out on bond, he has Mr. Kimler. I did suggest that them watching the video together before the next announcement would be very beneficial. I do have a concern with his out-of-state residency, not necessarily that he remained here, but he has some felony priors in Oklahoma, Judge, and I don't know if the court might think it advisable to have him put on the GPS so that we know where he
You're already on a
Okay.
GPS? Okay.
For my body.
Okay. Okay. Make sure you follow all of the conditions of your bond, whether it's court conditions or conditions with your bonding company, okay? And again, make sure you get with Mr. Kimler. I want y'all to watch that video before that next court date, okay? All right, you're free to go.
What a session! From plea rejections to probation warnings, every decision here carried real weight. We saw Dissandra Joseph Gamble on trial, Anthony Williams earn a second chance, and Christopher Burkett learn that bond violations can end it all. Others, like Caden Jones and Charles Newman, played their cards smart with strategic plea deals. The courtroom isn't just about justice, it's about choices under pressure. So what do you think? Who made the smartest move today? Drop your thoughts in the comments. And if you found this breakdown as gripping as we did, hit that like, share, and subscribe for more real courtroom drama and expert legal insight only here on Courtroom Chronicles.